Okay, so just finishing up here, it's important for us to realize that there's also a consideration about civil rights as it applies to people of a certain age, as it applies to people with certain disabilities. So let's think about civil rights in the grain of America. In other words, how civil rights also apply to elderly people in the United States. In 1975, we saw the passage of the Age Discrimination Act, which basically made it so that if there was any institution that denied equal employment for people over the age of 40, that federal funds would be denied to these institutions. But it is relatively difficult to prove age discrimination nonetheless. So it's an important extension of civil rights towards people over a certain age, but at the same time, relatively difficult to enforce. Jobs also cannot require forced retirements unless employers can prove that people of a certain age have compromised abilities to do their jobs. So basically, if you are of a certain age but you're still of perfect health and you're still doing your job perfectly well, you can't lose your job. People with disabilities, also very important extension of civil rights and something that's relatively recent in history. First, you have the Rehabilitation Act of 1973, which basically meant that anyone with a disability could not be discriminated against under the law. The Americans with Disabilities Act, a very significant act in 1990. Here we see George H.W. Bush signing it into law. Basically, this made it so that public facilities have to make reasonable accommodations and prevent discrimination in the workplace. So the Americans with Disabilities Act is one of the reasons why we have increased access to public facilities like wheelchair ramps, for example, an increased number of handicapped spaces in parking lots. This is also important because if we go back to our discussion of federalism at the very beginning of the year, you may remember mandates. Right, certain obligations that the federal government places on states and local governments, right, to provide additional facilities. This is an example of an unfunded mandate, if you remember that. Gay and lesbian rights. So Bowers versus Hardwick. This was a case where the court said that states could ban homosexual relations. So you're actually going to see that gays and lesbians in a lot of ways still face the toughest battle for equality of any of America's minority groups, and we could ask the question of why that is. Some states actually continue to allow prejudice in hiring, education, and access to public accommodations and housing. We also know that there was a don't ask, don't tell policy that was implemented by the Clinton administration in 1993, basically making it so that people in the military were not supposed to divulge their sexual orientation. But an important change to that, of course, is that this was repealed by the Obama administration in 2010. You have seen gradual victories for gays and lesbians, especially in recent years. Now gay marriage is actually legal in 38 out of the 50 states. You also have seen 7 states pass laws that protect homosexuals from forms of discrimination. So there have been some significant strides. Affirmative action, definitely one of the more controversial issues regarding civil rights still. So let's go back to the Lyndon B. Johnson administration with the Executive Order 11246. What this does is this bans discrimination based on race, color, religion, sex, or national origin in federal contractors. All right, so in other words, making it so that one cannot be discriminated in terms of hiring based on these above criteria. Also, according to this executive order, employers had to basically set quotas or have goals to increase the number of women and minorities that they hired. So clear example of affirmative action here. Now again, with affirmative action, a lot of people argue that this might go into the direction of reverse discrimination, and this is still something that is up for debate. But in general, we need to be familiar with just a definition of affirmative action, and that is that it's meant to kind of increase equality of opportunity for groups that have previously experienced discrimination. So again, people like women, people of color. Now this actually shows us that there's an increased attention to equality of results, which we talked about in the first video, which is something that a lot of people do not actually support. Most people support equality of opportunity, But equality of results implies that everyone gets the same thing in the end, which certain people argue is going a little bit too far. An important affirmative action Supreme Court case that you should know is Regents of the University of California versus Bach. This is 1978. The University of California in Davis had an affirmative action plan that was rejected by the Supreme Court case. And there were also additional cases that sort of elaborate on what universities can and cannot do according to affirmative action policies. So the reason why the UC Davis affirmative action plan was struck down was because it set a quota, right? 16 out of 100 applicants were basically people who were considered disadvantaged. These 16 were basically given spots based on that classification. Now, again, this was declared unconstitutional, but you are going to see that the court still said that you can use race as part of your consideration of the admission process, but you just can't set the quotas. All right. And again, there have been elaborations on that process with two 2003 Supreme Court cases, Gratz versus Bollinger, which says that universities can't set quotas, but then Grutter versus Bollinger of the same year said that universities can include race or ethnic background as an element in the selection process. All right, so again, the whole reason why the UC Davis quota system, the whole reason why the UC Davis affirmative action program was struck down was because of their use of quotas. All right, so in general, we can kind of infer that civil rights have expanded, especially over the course of the last 50, 60 years or so. We see that ultimately that the scope of government has increased over time because of the increased attention to civil rights, that there have been a significant number of amendments, right, to the Constitution that have dealt with civil rights in particular. The 13th and 15th Amendments we know, the 24th Amendment as well in 1964. We have all the Civil and Voting Rights Acts in the 1950s and 1960s, right? So you kind of get a sense of how much larger the government has had to grow. Quick recap, important things to take away from this chapter, things that you should definitely study for the AP exam. What the 14th Amendment does, how this is the first amendment that ultimately mentions equality, and how this applies to both the federal and state governments. Also, be sure you can delineate between reasonable scrutiny, right? So things like age restrictions, inherently suspect. So if a law makes a distinction based on race, this is something that is considered inherently suspect, and intermediate scrutiny that tends to apply to gender specifically. It's important for you to realize that the 1954 Brown versus Board decision reverses the 1896 Plessy decision, right? And that also the Brown decision outlaws de jure segregation, right? So you should know the difference between that and de facto. I already actually mentioned the 24th Amendment prior, but these are also things you should be familiar with. Civil rights, voting rights, okay, so 1964, this act, 1965, this act, and this is a 1964 amendment. Title IX as well, the Americans with Disabilities Act, right, and the Regents versus Bach case. All right, so, actually it's a relatively short chapter. Again, about 5 to 15% of the AP exam actually covers this. So that's one of the reasons why this was a very quick overview. So remember to answer the Chapter 5 essay question on the take-home test, and we will pick up with public policy after break.